welcome to another episode of Supreme Court Judgments of the Week on Verdictum. In this segment, we bring to you the most interesting judgments passed by the Supreme Court during the previous week. Let's begin. Starting with the Bilkis Yaqub Rasool versus Union of India and others. In a landmark ruling, the Supreme Court overturned the grant of remission to 11 convicts on a writ petition filed by Bilkis Bano, a victim of gang rape and violence during the Gujarat riots of 2002. The accused were convicted, having been found guilty of committing gang rape on Bilkis, who was 21 years of age and also pregnant at the time. The incident also led to the murder of her family members, including minors. Although initially the case was being tried in Gujarat, in 2004, a transfer petition was filed before the Apex Court, seeking the transfer of the trial from the state of Gujarat to a neutral place. In furtherance, the case was transferred to a competent court in Mumbai for trial and disposal. The Mumbai court passed a judgment in 2008, convicting 11 accused. In 2013, a division bench of the Bombay High Court made the order in response to a plea preferred by one of the convicts, holding that where a trial has been transferred from one state to another, such trial resulting in the conviction and imprisonment, the prisoner should be transferred to the prison of his state. The case took an unexpected turn when one of the convicts, namely Radheshyam Bhagwan Das Shah, moved an application before the Secretary, Department of Home Affairs, State of Maharashtra, seeking an early release, citing an order passed by the Gujarat High Court granting him liberty to approach Maharashtra for premature release. The plea was, however, opposed by the Central Bureau of Investigation, which was handling the case. In August 2019, the CBI submitted a report recommending against the premature release. This was echoed by the Special CBI Court in Mumbai in an order dated January 3, 2020, which ruled against the early release based on the severity of the offence. An application was then filed by the convict Radheshyam before the High Court of Gujarat, stating that the state of Maharashtra was not the appropriate government for exercising the powers of remission. This application was rejected by the Gujarat High Court through an order dated March 13, 2020. In furtherance, a writ petition was filed before the Supreme Court on May 13, 2022. The top court directed the state of Gujarat to consider the application for premature release in accordance with its policy dated July 9, 1992, applicable at the time of conviction. Following the Supreme Court's decision, a meeting of the Jail Advisory Committee of the state of Gujarat convened in May 2022. Surprisingly, all committee members recommended the grant of remission not only to Radheshyam but also to the other 10 convicts. The same was also confirmed by the central government. Thereafter, the state of Gujarat issued the remission order dated August 10, 2022. This particular order was challenged before the Supreme Court and a quashing of the said order was sought. A bench of Justice B.V. Nagaratna and Justice Ujjal Bhuyan considered questions of importance, such as whether the government of the state of Gujarat was competent to pass the remission order and whether the said order passed in favor of the convicts was in accordance with law. The question as to which state government was competent to grant remission was answered by the Supreme Court, and it was held that the appropriate government envisaged under Section 432 of CRPC entitled to such decisions should be the state where the trial took place, in this instance Maharashtra and not Gujarat. The court emphasized that the determination of the appropriate government centered around the trial's location, not the crime's location or the convict's place of imprisonment. With regards to the question of the legal competency of the remission order, the top court held that the order lacks competency and was hence a nullity. Moreover, it was held that the writ petition filed before the top court, which resulted in the grant of remission by the state of Gujarat, was fraudulent in nature for having suppressed material facts. The court, expressing disappointment, said that the convicts had not come to the court with clean hands and had abused the process of law. The court, in furtherance, termed the order per incurium and quashed the remission order. It further directed the convicts to surrender back to prison within a period of 2 weeks. Surgarodia versus the state of Assam and another. In the present case, the Supreme Court made a decision to quash charges of rape and criminal intimidation against an accused individual due to a staggering delay of 34 years in filing the first information report. The accused had approached the apex court in appeal of the dismissal of his application under section 482 of the Code of Criminal Procedure 1973 by the magistrate in the first instance and the Guwahati High Court thereafter. The complainant has asserted that the accused committed rape when she was 15 years old, which also resulted in the birth of a child. The court, however, took into account the evidence, suggesting a consensual relationship between the parties. It was also revealed that the son of the complainant acknowledged the accused providing financial support, further suggesting a collaborative effort in filing of the FIR, possibly driven by greed for property. A bench of the Supreme Court comprising Justice B.R. Gavai and Justice Sandeep Mehta emphasized that the filing of the case after such an extended period of time, solely on the grounds that the complainant was a minor at the time of the offence, could itself be sufficient to quash criminal proceedings. Notably, the court found a glaring absence of any explanation in the FIR regarding the complainant's silence over the 3-decade period. Disagreeing with the findings of the magistrate, the apex court underscored, when exercising powers under section 190 of CRPC, the magistrate is not bound to accept the final report of the investigating officer. However, if the magistrate disagrees with the findings, he is expected to give reasons for such disagreement and explain why he finds it necessary to take cognizance despite the negative reports submitted by the IO. In conclusion, the top court ruled that the continuation of the proceedings would lead to nothing else but an abuse of process of law, aligning with the investigating officer's submissions that the case was filed for greed of property in connivance by the woman and her son. The Supreme Court quashed the orders of the magistrate as well as the High Court. Denesh Gupta versus State of Uttar Pradesh and another. In the instant case, the Supreme Court quashed criminal proceedings in a case and imposed a hefty penalty of Rs 25 lakh on the complainant who warranted conversion of what the court deemed a civil matter into a criminal one. Presiding over the case, Justice Vikram Nath and Justice Rajesh Bindal underlined the imperative of holding unscrupulous litigants accountable by enforcing stringent terms, conditions and costs. The case revolves around a complaint filed by Karan Gambhir, the owner of DD Global Capital Private Limited, against individuals and private limited companies, including Denesh Gupta, Sushil Gupta, Baljit Singh and others. Gambhir alleged fraudulent practices involving short-term loans, debt equity conversion and forgery. The transaction in question, involving a short-term loan in 2020, raised eyebrows as efforts to recover the amount were initiated only when the FIR was filed nearly 8 years later. The court found evidence of deliberate delays while also highlighting the complainant's intentional concealment of facts. The court noted that the complainant made deliberate attempts to mislead by providing incomplete address and observed that the trial court had issued summons without proper consideration. The court further noted that there were indications of a malicious attempt to initiate criminal proceedings with ulterior motives. In furtherance of these findings, the apex court allowed the appeal, setting aside the High Court's order and quashing the FIR and subsequent proceedings against the appellants. With that, I am Anya Singh. Thank you for watching Verdictum. Your time and engagement are greatly appreciated. If you enjoyed the content, don't forget to like, share and subscribe to our YouTube channel. And download the Verdictum app on iOS and Android for latest legal news.